Welcome to Divorce 101, New Jersey divorce process. You're all here because you want to know how do I start my divorce and what to expect. I am Bari Weinberger of Weinberger Law Group. I'm owner and managing partner, and I'm here to help you with this issue and help you answer your questions. So let's get started. Divorce 101, the New Jersey process, has a number of stages. These are the stages that we are going to go through today, and we're going to cover these matters and hopefully answer your questions. Stage 1, beginning the divorce process. Now, the typical New Jersey divorce begins with filing a complaint for divorce. What does the complaint actually entail? Well, the complaint actually covers the grounds for divorce. You have to choose which grounds to select from. There are a number of grounds within the state of New Jersey and the statute that you can choose from. Irreconcilable differences, extreme cruelty, infidelity, which is adultery, and many others that are available to you. You can choose one, you can choose several, in fact. New Jersey is actually a no-fault state, which means that most people really gravitate toward irreconcilable differences, but it doesn't mean that you're locked into that particular one. Fault-based grounds are also available, such as the adultery-based option. Now, you should talk to your lawyer and find out which is best suited for you and what are the benefits and what makes the difference between that one versus the other. Now, your matter, your complaint for divorce, has to be filed in family court in the Superior Court of New Jersey in the county in which you or your spouse reside. Now, do you have to prove that your spouse actually did something wrong in order to get a divorce in the state of New Jersey? The answer is no, you don't. That's why New Jersey is a no-fault state. That's the benefit of being here, actually. Amongst other things, we happen to like being here in New Jersey, right? So irreconcilable differences is available. What does it mean? What is that term? It means that you only have to identify that there has been a breakdown of the relationship for a period of at least 6 months. You don't have to identify what that breakdown entails. That's the brilliance of this particular ground. It means that since your complaint for divorce is in fact part of a public record, your nosy neighbors, your employers, or anyone else who might be snooping around this courthouse and your documents won't find out anything about your personal matter. And that is very, very relevant to some of you. Some of you might not really care, but you should know that that is meaningful and it's available. Now, divorce mediation. Is this a viable solution for you? Is it a proper process and one in which you are a ripe candidate for? Well, mediation has its benefits for many people, and you should know that it is a process that helps settle many, many cases. It's a neutral, a confidential, and a fantastic option for those people who want to go and sit at a round table and work out their differences together. You have to have both parties who are willing to come to a table and make compromises, who can identify their issues and sit down together and work out their issues, whether it be child custody, child support, and alimony, distribution of assets. You have to be able to identify what issues exist and be able to sit down with a neutral facilitator and work out those issues. And the mediator is that neutral facilitator. You can go just with the mediator into a room with your spouse, or you can go with your attorneys and the mediator. Talk to your attorney about whether or not this is a viable option for you. It works in many cases and can in fact be a cost savings as well. Now, the initial divorce papers. What in fact is contained within the complaint for divorce? Well, we already talked about the grounds for divorce. Many people have a question about whether or not they are going to be the plaintiff or the defendant. Well, you should know that the person who files the initial complaint for divorce is always the plaintiff, from the inception of filing the complaint for divorce to the conclusion of the case. For the entirety of the matter, they remain the plaintiff. And in fact, they will then file the papers, send it to the courthouse, and when they get the papers back from the courthouse, they will have a period of time within to serve the other party. The other party will have to then get the papers within a period of time of about 10 days. That's considered reasonable by the court. And the receiving party becomes the defendant for the remainder of the case. And that defendant then has a period of approximately, or definitely, in fact, from the date they receive the papers, 35 days. 35 days in which to answer the complaint or otherwise provide a counterclaim. The counterclaim is when the defendant gets to say, I too want a divorce, and here are my grounds. If the defendant doesn't answer at all, then the plaintiff has the option to say, hey, listen, court, I filed my complaint, and the defendant never responded. So I want to serve a default upon the defendant so that I can continue with the process without the defendant's participation. Sometimes this happens when you can't locate the defendant, or the defendant is otherwise unavailable because, let's say, they're digging their heels in and they don't want to participate, or they're in denial. Now here's a flow chart that identifies the divorce process from the beginning ultimately to, so that you can go follow along and you can see the time frames available. So take a look. It helps you create a framework and a better understanding. Stages 2 and 3 talk about the case management process and the discovery process. Let's go through in a little bit more detail. I'm going to go back for a moment. The case management process. So within 30 days of the filing of the answer to the complaint or the defendant's counterclaim, there is going to be this case management conference. And the case management conference is scheduled with the court, and it's where the attorney has to fix deadlines for discovery. And this is very administrative. It's something that the attorney and the judge gets to do, or an administrator with the court, depending upon the county. Sometimes they do it differently from county to county. And it's scheduling discovery depending upon the issues in the case. And they'll be determining whether or not there is going to be a necessary experts and so on. Temporary motions. A lot of you want to know whether or not you can get immediate relief right now. So after you file your complaint for divorce, the court knows that you exist. That's when they enter you into the system and the computer recognizes you. You have been entered into the database, so the court recognizes X versus Y is now in the system. So what happens when you need immediate relief? We have something called pendente lite motions. That's just a Latin term for pending the litigation. What it essentially means is that from the filing of your initial pleading, that complaint or that counterclaim, up until the time that your matter is finalized, whether it be a settlement agreement or a final trial and a judgment of divorce, you can ask the court for temporary relief in this form. Filing a motion for child support, temporary custody and parenting plans, or otherwise temporary alimony and spousal support or visitation and so on. So you can go to the court if you can't work out reasonable negotiations and settlements for interim relief. So what do you do if you have a custody or a parenting time dispute now? Well, there's no question that the court is going to recognize in your complaint for divorce that in fact custody is an issue. You have to identify it. And once that happens, the court is going to send each and every one of you to court-mandated parenting mediation. It's one way that the court says, we're going to try to make you work this out on your own, but we're going to try to help you do that. The court has on-staff mediators at the courthouse itself, and they're going to assist you in going. So the spouses go together, you and your spouse will appear at the courthouse without attorneys on that occasion, sit with the courthouse mediator, but you're going to prepare with your lawyer in advance, and you're going to know exactly how to handle this particular session. And you're going to participate in this court-mandated mediation session. This will be identified in the case management order and your attorney will deal with that at the case management conference. What else will you be entitled to do, and what will be available to you for a parenting and custody opportunity to settle your case in advance of having to go to a final trial or a hearing? Well, the court is going to require you to go to court-ordered parenting classes. It might seem trivial to you. Many of you think you are not in need of parenting classes, and most of you probably don't need parenting classes. But the point of the parenting classes through the court is not to tell you you're bad parents or tell you how to better parent your children, but instead it's to give you an opportunity to understand how the court is handling the custody and parenting time issues, and so that you can understand how this is going to be facilitated through the divorce process. So you and your spouse will be directed to go to the court in an evening, but you're going to be given different dates to go, so you don't have to sit in the room at the same time, given the fact that there's likely a dispute, and you probably don't want to have the opportunity to ask questions of the available people there, a judge and the mediator, at the same time that your spouse is sitting in the same room. You're also going to be expected to propose parenting schedules, custody and parenting time plans on your own. This helps facilitate ultimate agreements and settlements so that your matter need not go to the ultimate trial and can be resolved amicably, or as amicably as possible. Then ultimately you have that court-ordered mediation that we talked about moments ago. So if you can't resolve your parenting issues through the negotiation or mediation, the court is absolutely going to want experts involved. The case management order is going to reflect the experts, and it's going to reflect time periods by which expert reports will be necessary. Now, these custody investigations and evaluations are imperative. You can get joint experts where you and your spouse can share in the cost of one expert, and that person is going to be neutral and is going to serve in the capacity of investigating and evaluating your family as a whole. They'll meet with you individually, your spouse individually, you and your children together, your spouse and your children together, and then render a report and a recommendation ultimately as to who will serve as the parent of primary residence, who will serve as the parent of alternate residence, whether or not there should be a certain time sharing plan, whether or not there should be supervised parenting, and so on and so forth. So either of you can choose to have independent experts, whereby you don't have to have a joint expert. You can choose to have your own expert. You have your own, your spouse has your own, and ultimately you have to pay for that expert on your own. And funding will have to be discussed with your lawyer. How is it going to be paid? From what assets? From what income? And so on and so forth. And the custody evaluation experts are going to render their respective reports. And the court might ultimately decide that the judge, in fact, might want an expert as well. Best interests of the children will ultimately be a necessary bottom line foundation in everything that is handled. Many people want to know, can my child come to court? And if the child can come to court, can the child indicate what his or her preferences are? Most cases, the judge wants to make that a last resort. So keep that in mind. But it should be discussed with your attorney whether or not that is an option to be considered. Now, what happens with financial experts? There are certain elements of the case that will ultimately require a financial analysis. Dividing assets and debts, determination of alimony, that's spousal support, and ultimately, of course, child support. Also, business valuations, and so on and so forth. You're going to need to determine at the case management conference level and thereafter what experts will be needed, such as financial advisors, forensic accountants who will go in and investigate certain assets such as businesses, whether or not a real estate appraiser will be needed, or instead maybe just a comparative market analysis by a realtor, or in fact, whether or not you need a pension appraiser for assets that will ultimately be divided, retirement assets, or even a vocational expert. What's a vocational expert? Most people ask. Well, that's when you have a spouse who might have been a stay-at-home parent for a particular period of time, and the other spouse is indicating that that parent has an ability to earn, a capacity to go out and work, they have skills, they have an ability to go and have income imputed to that spouse to go and ultimately have income to help alleviate the entire alimony obligation of the other spouse. That needs to be discussed with your attorney to find out which experts need to be involved. Let's talk about discovery for a moment. Discovery is oftentimes in the form of a case information statement. That, in fact, is a material document that we're going to talk about in a moment, and it is, in fact, the lifeblood, in my opinion, of almost every case. I'll get to it in a second. And in fact, discovery in general, which will be discussed at the case management conference, which we talked about moments ago. Now, this case information statement is essentially a net worth statement. It provides some general information about you and your family. It talks about your respective incomes, the spouses themselves, last year, this year, year to date. It also identifies your household budget, your shelter costs, your transportation costs, your personal costs, not just you, but your whole family, your whole household. How are you living? What are your grand total monthly net expenses? At the end of the day, how much are you earning, net dollars, versus how much is going out to care for your total house? And then what is left for savings? The net worth statement also identifies the delineation of your assets, everything, all in, you, your spouse, as well as joint assets. It also identifies your total debts. What is it that are your liabilities? And then it is a global snapshot of your financial picture. This tells the court what exactly exists. Sometimes you don't know. Sometimes it has to be determined. And that's the brilliance of the discovery in the divorce case. So when a spouse comes in and says, I don't know, well, we have to investigate. We have to figure it out. So we do that through the next phase, which is document demands and interrogatories and depositions. Sometimes we have to send out subpoenas and we have to ask companies to identify for us records and bank statements and credit card monthly statements, deeds, title documents, business records, and have the other side answer interrogatories, which is a whole host of questions that we're going to pose to the other side so that we can elicit the answers necessary for us to fill in the blanks and put the puzzle pieces together so that we can create the case most beneficial for our client to move forward and make a financial settlement package that makes sense. It's favorable to our client, but it's fair and reasonable for the whole family. The depositions are, in fact, when there are still missing pieces and we want to put the other side or an expert in a room and say, we have questions for you, and while we're in a conference room in my office and we're all comfortable, there's a stenographer at the end of the table and that person is recording everything and you're under oath and you have to answer these questions as if you were sitting in a court of law. Stage 2 and 3 also has a flow chart here, case management and discovery, so that everything that we just discussed actually is here and available to you for review. Stages 4 and 5 are the early settlement panel and economic mediation. Now, trials are expensive, they're burdensome, and most people want to avoid them. And in fact, most people are successful in avoiding them. New Jersey has provided statistics for us that says, in fact, less than 5% of all divorces that are filed in the state of New Jersey result in an actual trial. It doesn't mean that we don't go to court. We actually do go to court quite often, but that's for interim relief, for case management conferences and for other types of matters before the court. But for the final trial, very few matters actually end up at a full-blown hearing. There are means by which we go to these other stages, such as early settlement panel and economic mediation, that assist us in helping to facilitate a final settlement. Now, we use this as means by which to negotiate. What is the early settlement panel? This is a process by which either 2 or 3 experienced volunteer family law attorneys come together. Depending upon the county, it's 2 or 3 attorneys. They sit in a room, they get your advanced respective position papers as to what you're looking for in final settlement. They get your case information statements and other financial documents, and they analyze them. They have no axe to grind. They're not interested in you personally. They don't know who you are. They're there as independent, neutral people. Their recommendations are, in fact, confidential, and they're there to give you an opinion. If they were wearing the black robe that day as a judge, what would they do as an experienced lawyer who does this every single day, and what would they recommend as a final settlement? And they collaborate, they look at your respective positions, and they try to give you some feedback so that you could try to settle your matter. And in fact, when you go to court with your attorneys that day, and your attorneys present your positions to this panel, and the panel gives you recommendations, if you agree with the recommendations, you in fact could get divorced at the early settlement panel date that date before leaving the courthouse that day. It's an incentive to try to resolve your matter. Sometimes it just serves as a really solid foundation to try to assist you to move forward in productive discussions for final resolution. Economic mediation is the very next step. If you don't resolve your early settlement panel matter, if you don't resolve your matter on the early settlement panel date rather, you go to economic mediation as the very next step. It's not in the courthouse, but the 2 lawyers choose an economic mediator, somebody that they believe is qualified to assist in a settlement-minded sit-down. And all of you go to that person's office and you sit and you work together. The economic mediator's time is free for the first 2 hours, generally 1 hour of their advanced preparation time, because they're going to get your early settlement panel papers in advance, and they're going to review them and become prepared before you even enter in the room, and generally there's 1 hour of free face-to-face time. You sit down and you try to collaborate and come together. Now, it's called economic mediation for a reason. They only talk about financial issues. They will not discuss custody and parenting time. You'll go there and it's another opportunity to resolve your case. The court is putting together these steps necessary for you to try to keep your matter out of trial. It's another brilliant opportunity to just get you to a settlement table. Here's another flow chart that identifies the stages of early settlement and economic mediation for your availability and review again later. Now, in the event economic mediation is not successful, the court sets forward another opportunity. What's next? Well, we put together stages 6 and 7, intensive settlement conference and trial. Intensive settlement conference is in fact when the early settlement panel stage has not been successful, economic mediation has not in fact been successful. We're not done yet. You don't get to go to trial yet. The process allows for this intensive settlement conference. It means now you go to court. You sit there with your lawyers and you spend an entire day at the courthouse with your lawyers and you try to resolve your case. You're generally there from the very beginning of when the courthouse opens to when the courthouse closes. And the judge is usually committed to trying to give you as much time as possible to assist you in resolving your case. The judge will try to give you feedback, and the judge will try to help you narrow your issues so that you can come to terms without moving forward to trial. If it doesn't work out and you have to move to the next stage, trial is in fact the next stage. If you go to trial, the trial court is probably going to give your attorneys a document in advance that says everything that's necessary to submit in advance of trial, such as exhibit lists, witness lists, trial briefs, and other types of advance demands. So if you do go there, evidence has to be submitted, trial binders have to be submitted, and the judge is going to listen to testimony from you, your spouse, expert, other witnesses, and ultimately will have to render a final decision based upon all of the evidence presented and the documents presented and the exhibits, and will have to determine what is right as to all unresolved and disputed issues. Now, barring any appeals of the judge's decision, there's going to be a judgment of divorce, and those are going to be final orders. Here's a flow chart of that intensive settlement conference and the trial phases, the stage 6 and 7. Now, the New Jersey divorce process also includes post-divorce motions for enforcement. So let's say you finally have a divorce and you have your settlement terms and or a judgment of divorce, or even during that pendente lite temporary phase, a judge had rendered an order on one of your interim motions, a motion for child support or temporary parenting time plan or support. And let's say your spouse has not complied with those orders. You're not without remedy. You can go to court and you can in fact ask the court for enforcement. Ask the court to say, there has been a violation. My spouse has failed to comply, and I would like you to hold them accountable for their failure to comply. That's in fact a motion to enforce litigants' rights, and ask the court for some type of remedy, whether it's for the support-related issues, parenting time-related issues, visitation, and such. There's also relief that you can ask for in the form of modification. Just because you have a court order in place doesn't mean you're in lockdown mode. It means that you have an opportunity in the future generally to seek modification in the event that there is a substantial financial change in circumstances. It's not in every case. It depends upon the language and the case law and the circumstances of your particular matter, but don't feel like you are necessarily barred from relief. Talk to your lawyer about what remedies are in place for you depending upon your particular issue, because you might in fact have modifiable issues and conditions. So that completes our Divorce 101, the divorce process. I'm hopeful that this has given you an overview of all that is involved in this particular scheme, if you will, and I hope that it has answered all of your preliminary questions. If you have other questions, don't hesitate to reach out. Our telephone number is identified here, as well as the email address. We are available for free, confidential initial consultations. It's our pleasure to assist you. Reach out at any time. It is a challenging and it's a complex process, but you don't have to go it alone. Just make sure that you have the support necessary and that you have the backing and the people behind you and the information and education and tools necessary to make the decisions right for you and your family. And always know that you have the tools to make decisions that are right for you. Please, good luck, and it was my pleasure to provide you with this information today. Please be well.